All right. Today in the Menendez hearing, the court heard two motions. The first was a motion to recuse the district attorney's office. That motion, as we argued in our papers, was completely devoid of merit. And we thought, in fact, we argued it was a desperate and last-ditch motion, not to deal with the facts of resentencing, but to try and throw off the entire district attorney's office based on some alleged conflicts of interest. That motion was so devoid of merit that we believe the defense actually decided to pull the motion, which is exactly what they did. They didn't even have the judge rule on the motion because they must have known the judge was going to deny the motion, and they actually told the judge that we're going to pull that motion. And the judge then took that motion off calendar and didn't rule on it because it effectively has not been brought. The second motion was a people's renewed motion to withdraw the petition for resentencing. We argued that there was a new set of facts that led the court to reconsider its prior ruling on denying that motion to withdraw the petition. Those new sets of facts were comprehensive risk assessments. They were prepared by board-certified psychologists for the Board of Parole hearings, and they went through an extensive analysis, a written analysis, in which they looked at all the various factors of whether or not someone constitutes a risk for violence. They determined that each of the Menendez brothers constituted moderate risks of violence, which was higher than the prior determinations of low risks of violence. They said they referred to certain instances that led them to those conclusions, including the fact that, for instance, for Eric Menendez, while the resentencing hearing was actually a possibility, the motion had been filed in October of 2024, but in January of 2025, he brought an illegal cell phone into the prison setting, enlisting another prisoner and someone outside to do that for him. He was caught violating the rules. And the psychologists looked at that and they said, if someone is willing to risk engaging in a rule violation while they're actually involved in a resentencing, what does that say about their risk of conforming to the standards of the law if they were released outside of this structured environment? And they determined that they posed a moderate risk of violence as opposed to the low risk which had been assessed before. With Lyle Menendez, they also looked at a variety of rule violations in which he had engaged in, reaching the same conclusion, that he no longer posed a low risk of violence in the future, but posed a moderate risk. So we used this new information to renew our motion. And we said to the judge that this new information effectively meets the legal standard to allow a district attorney to withdraw a motion that had previously been filed because it shows that a change of circumstances where the prisoner is less deserving of resentencing. That is the standard. A change of circumstances where a prisoner is less deserving of resentencing. And we made that argument to the judge, and ultimately we said that the issue with the Menendez brothers is not never, that they should never qualify for resentencing. We said it was not yet. That in light of the findings of senior psychologists from the Board of Parole, in light of the prior arguments that we had made, that the Menendez brothers have never come clean for over 30 years, with the fact that they're self-defense, where they said that their parents were going to shoot them each, the mother and the father, the night of August 20th, 1989, so they had to shoot them first. The lies where they tried to enlist one of Lyle Menendez's girlfriends to say that Jose Menendez was a violent rapist, a complete lie she would not say. The fact that they enlisted another girlfriend to go ahead and lie and say that the mother was going to and tried to poison the entire family. These are the significant lies that the Menendez brothers have never come clean with over the last 30 years. You add in the findings now by these board-certified psychologists that also talk about deceit. Deceit meaning that they no longer constitute the low level of risk, but have risen to a moderate level of risk. And that's why we asked the court to allow us to withdraw that motion at this time. It doesn't mean that we wouldn't refile the motion in the future if circumstances change to show that the Menendez brothers have truly gained full insight into their actions and accepted responsibility, but that time was not now. The court heard all our arguments and denied our motion. So the court then set the resentencing hearings for Tuesday and Wednesday of next week, at which point witnesses will be presented, and the court will either rule at that time or take it under consideration.